Good morning, afternoon, evening, and welcome to Concerned Citizens Presents, a new offering on Village TV. Concerned Citizens of Laguna Woods is an organization committed to peace, social justice, economic equality, and a clean environment. For the duration of the lockdown, instead of its usual 2 meetings a month, Concerned Citizens will broadcast 2 programs a month on this channel. Our programs will feature films, lectures, and debates on topics related to our mission. We hope you enjoy today's program.
Welcome to Concerned Citizens Presents, a series of talks with interesting speakers on important issues within our purview of peace, economic and social justice, good government, and protecting our environment. You can view them on Village Television every Wednesday from 1 to 2 p.m. Our program today is our 14th annual Supreme Court term review. We started it in 2008 with the first 9 annual talks to us by UCI Law School's generous Dean Erwin Chemerinsky. After Erwin left for Berkeley, UCI Law's best kept that tradition of service by giving those talks each year. 2 of this year's outstanding speakers from UCI Law, Chancellor's Professors Michelle Bratcher Goodwin and Rick Hassan, are national leaders in their fields. Our purpose has been viewers' understanding of how Supreme Court decisions often impact our lives, that who its justices are matters, and therefore who nominates and confirms them matters. Michelle Goodwin is a UCI Irvine Law School Chancellor's Professor, founder and director of the Center for Biotechnology and Global Health Policy, and its widely praised Reproductive Justice Initiative founder and director of the Center for Biotechnology and Global Health Policy. Her wide areas of expertise include constitutional law, family law, health law, reproductive rights, and bioethics. She's a prolific author and an acclaimed constitutional law scholar and bioethicist. She's an elected member of the highly prestigious American Law Institute and a fellow of the American Bar Foundation and of the Hastings Center, the organization central to the founding of bioethics. She hosts the podcast On the Issues with Michelle Goodwin at Ms. Magazine. Its slogan, I quote, is reporting, rebelling, and telling it like it is, unquote. She has guest lectured or given workshops at most of the top universities and law schools in the U.S. and some abroad. Her writings address pressing matters of law, society, and global health. She's an award-winning author. Her publications appear across 5 books and over 100 law reviews in all of the nation's top law reviews. So, if you'll unmute Michelle, the floor is yours to talk about things that might start with the fact that we have a huge surprise this morning in Texas. And welcome,
That's right.
Rick. Thank you for joining us.
Thank you for the very generous introduction and for inviting me to be with you and also the viewers and listeners to this very important and special review. You are right. In Texas, what has now gone into effect is a law that is known as SB 8. It is a law that restricts abortion after 6 weeks of pregnancy, a time in which many people who would be pregnant would not necessarily know that they are pregnant or have an unwanted, unintended pregnancy. The law is quite complex in a number of ways. The simple version of it is that it restricts abortion rights after 6 weeks, and that it also provides a private right of enforcement by random citizens. That's the simple part. But that simple part is also the scarier part of the law, and there are added complications. The scarier part of the law is that in allowing private individuals to enforce this Texas law, it creates a specter of vigilantism written into law, such that individuals may in fact desire to surveil, and seek some form of remedy up to $10,000 against individuals who aid or abet in the termination of a pregnancy. The law is written so broadly that this would capture potentially anybody who provided a ride for someone who wanted to terminate a pregnancy, for someone who facilitated in some means of a person getting to an abortion clinic, or actually accessing the procedure. That is one level of what makes the law complex and also a bit dangerous. I'd urge your listeners to think about this as not necessarily being something new within law, a private right of citizens to bring a claim against someone seeking to be autonomous and free with regard to their bodies. The Fugitive Slave Acts did essentially the same thing, weaponizing random citizenry in the obtaining the surveillance, the obtaining of other people to deny them a right to freedom. Let's be clear that abortion remains legal in the United States. Roe v. Wade has not been overruled. Planned Parenthood v. Casey, which followed two decades after Roe, has not been overruled. The fact that the Supreme Court did not intervene in this case adds to the concerns that I think you spoke to in the introduction, which is a changing and shifting Supreme Court. What also adds to the complexity of this is that before the district court could actually rule on this matter, the Fifth Circuit Courts of Appeal denied them that opportunity by basically allowing the law to go into effect, meaning that it would be only the United States Supreme Court that could, in fact, overturn that. The fact that the Fifth Circuit did that was highly unusual, but something that has become more unusual within the last 4 or 5 years. It's something that we saw somewhat consistently, according to Justice Sotomayor, during the Trump administration. And that is a speed pass that has essentially been given. In her case, she was speaking to the Trump administration getting a speed pass to bring matters before the Supreme Court in order to overrule lower courts. In this particular instance, we see somewhat of the same. So one of the things that's implicated in this is judicial process itself. The fact that the district court was not granted the opportunity to fully hear the case and issue an opinion is truly disconcerting. It is not the case that the Supreme Court may not issue a stay. They may very well. We don't know that yet. Certainly what the court has done is something that is extraordinary, one could say. But it also has to be placed in context with several other cases. The Supreme Court later this year will hear a Mississippi abortion case. This case too is alarming and a bit unique in that it is a case that denies abortion during a period of non-viability. The same is true with regard to the Texas law, which is counter directly to Planned Parenthood v. Casey, which is the controlling law of the land. In Mississippi, it's a 15-week abortion ban, and in addition to banning abortion after 15 weeks of pregnancy, the law currently has an injunction against its activation, if you will, in simpler, more layman's term. But in addition to that, what also makes this law really concerning for many is the fact that there are no exceptions that are provided for an individual who's been raped or an individual who suffered through incest. This makes the law quite unique in that even laws that have been written in the past that constrain the right to abortion or that hamper that right have provided outlets, if you will, for individuals who've been sexually harmed, such as through rape or such as through incest. And that this law provides no room for that is deeply disconcerting. Now, this is a case that the Supreme Court has decided to take up. Now, what makes that also interesting is that the court didn't necessarily have to decide to take up this case. This is a case where a lower court judge issued an injunction which prevented the law from going into effect, a procedural matter that people seek when there is a law that is harmful and that undermines a constitutional right, and for which they would likely win on the merits. That the Supreme Court has taken this up in a different era could mean that the Supreme Court was looking to clarify that Planned Parenthood v. Casey remains the law of the land. And the lesson that we get from Planned Parenthood v. Casey is that abortions remain legal in the United States and that states may not impose undue burdens on a person who is seeking to terminate a pregnancy. It is interesting that in the court today, with a makeup of more women than ever before, that it is a court that is on a path to undermining civil liberties and civil rights, not only within the abortion context, but we've seen this in other areas related to racial justice, such as in voting rights, which Rick Hasson will speak to, and also more broadly with regard to women's rights altogether. But that said, let me tell you about two other cases that actually help us to understand what's at risk coming forward and the complexity. So in 2016, there was another Texas case. That Texas case was a Whole Woman's Health v. Hellerstedt. That case related to HB2, two Texas laws that also sought to restrict abortion rights and to constrain the access to obtaining an abortion. Those were laws that fall within what we call targeted regulations of abortion providers, which has been one of the strategies that's been used in anti-abortion movements. That is to avoid going after the women themselves, and that is to go after the medical facilities, the clinics, the abortion providers. In that particular case, there were two restrictions, although there are many in Texas, but there were two that were taken on. One was a hospital admitting privileges. The Texas imposed a law mandating that doctors have admitting privileges who perform abortion have admitting privileges within 30 miles of their clinic. It's important to understand that Texas singled out abortion providers. It was not something that was imposed upon all medical providers, just those who perform abortions. The second was that clinics were supposed to realign to basically resemble hospital emergency rooms. Ambulatory surgical clinics basically was what the Texas law required that they become. This kind of retrofitting could cost hundreds of thousands of dollars, if not millions of dollars. The Supreme Court struck down, and this is when Justice Kennedy was still on the court. Scalia had just died. The Supreme Court struck down those two laws in an opinion that was written by Justice Breyer. One thing that was really important that we all understand and that Justice Breyer emphasized in the case, and this came from a very robust district court opinion. The district courts amassed the facts and analyzed the facts. And what was really important there was that there was a robust factual record, which included the fact that abortion is safer than carrying a pregnancy to term. A person is 14 times more likely to die by carrying a pregnancy to term than by terminating it. So,
Michelle, with my eye on the clock, that's an interesting transition to conclude with. That Justice Roberts, who is called an institutionalist, may have his eye on the institution of the Supreme Court, was the deciding fifth vote. And there has been a lot of talk that rather than overtly overrule Roe v. Wade, what the court might do is what was called death by 1,000 cuts, right? In each case to say that there was not undue burden. So looking ahead and looking at the politics, with midterm elections coming up and looking at the personnel of the court, what would you say about the prospects for both the 6-week and the 15-week abortion pregnancy limits and this crazy enforcement mechanism whereby anybody in the U.S. has standing to sue to enforce it? Can you conclude with those thoughts?
Yes, absolutely. That's exactly where I was going. So So Justice Roberts has to be concerned about the legitimacy of the court, and he has spoken to that in the past, that there are no such things as Trump justices, Obama justices, Bush justices, and judges. And so clearly that is something that is on his mind. And we saw that through the 2019-2020 term in cases where Justice Roberts voted in a way that would not have necessarily been predicted, let's say, voting with liberals on the court. Abortion right now, before this Supreme Court, it's a conservative 6-3 court, and abortion rights are vulnerable in front of this court. It will be, in fact, death by 1,000 strikes, because that has been the strategy deployed by anti-abortion movements. And we know that justices, at least one, has been quite sympathetic to that in a very long and rambling speech that this justice gave just earlier this year or last year. And so these cases are a part of that. These cases will, in fact, shape what the future of abortion will be. And the bottom line of that might be that states like California, New York, Illinois, and others become safe harbors where the court doesn't completely do away with Planned Parenthood v. Casey or undermine Whole Woman's Health v. Hellerstedt or June Medical, but yet at the same time lean into states' rights with regard to constraining abortion rights. And there, predictably, we will see Texas, we will see Louisiana, we will see Mississippi, and we will see certain other states that follow that pattern. And let me conclude with this. We can't have this conversation divorced from thinking about women's rights and racial equality, because these are laws coming from the very states that imposed slavery, not just for a year, a decade, a month, but for centuries were embedded in the constraining of civil liberties and civil rights of people in their states.
Thank you very much. Thank you very much for focusing on that. And we
My pleasure.
certainly are the beneficiaries of your experience in this area. And moving on now, please welcome again to Rick Hasson, also a Chancellor's Professor of Law and also political science. A nationally recognized top expert in election law, campaign finance regulation, legislation, statutory interpretation, and what I started law school with, tort law, first day of first week of first year. Rick co-authored leading case books in election law and remedies. In 2020, he was a CNN election law analyst. He was the analyst for the election last November. This year, very importantly, he co-founded and co-directs UCI Law's Fair Elections and Free Speech Center. Read all about it at law.uci.edu/centers/FEFS, which are its initials. And when we edit this recording, we'll put that up on screen for people. I really invite people to look at the center's website. Its 3 upcoming programs, by the way, are on disinformation in American elections. Also, most importantly, he founded the Election Law blog in 2003 to share news and analysis of election law issues. ELB is the go-to source for courts, lawyers, journalists, scholars, and the general public for news and analysis of issues, including campaign finance and those other things I mentioned, including ballot measures, recall elections, and legislation and statutory interpretation, and the rule of law, the basic one of all. So take it away on election law, and thank you for being here and part of this, Rick Hasson.
Thanks so much. And honored to follow my colleague, Michelle Goodwin, who gave a tour de force on abortion laws. I'll speak briefly about what's happening in the Supreme Court in terms of voting rights. And I think it's easy to lose sight of the Supreme Court's role in elections when we're not in an election season, but it is what the court does at particular moments in time that has profound implications for the elections going forward. And so let me just talk about 3 cases that the Supreme Court has decided over the last decade and a half, which together have really limited the ability of jurisdictions and especially of Congress to protect voting rights. So the first case is a case in 2008 called Crawford versus Marion County Election Board. In that case, the Supreme Court rejected a constitutional challenge under the Equal Protection Clause to a strict voting rule that the Indiana legislature had passed. Even though there was evidence that those people who have, say, the most difficulty registering to vote and voting are also people who are likely to lack identification. The court said that unless it imposes a big burden on a lot of people, such a law is constitutional. It left open the possibility of bringing narrow lawsuits for people who face special burdens, but those people are not going to have the resources to sue. And so the court gave the green light under the Constitution in 2008 to strict voting rules. This was followed in 2013 by the Supreme Court's decision in Shelby County versus Holder. This was a case where the Supreme Court struck down as unconstitutional a key part of the Voting Rights Act. It was a part of the act that said that jurisdictions with a history of racial discrimination in voting need to get federal approval from the Department of Justice or a 3-judge court before they can make changes in their voting rules. And they have to show that these laws that they proposed would not make protected minority voters worse off. The third in the trilogy of these cases that I want to mention came just this past July, a case called Brnovich versus Democratic National Committee. This was a case under the other key provision of the Voting Rights Act, Section 2 of the Voting Rights Act. And in that case, the court made it almost impossible for plaintiffs who want to challenge restrictive voting laws that make it harder to register or to vote, made it almost impossible to argue that these laws violate Section 2. Section 2 of the Voting Rights Act says that minority voters should have the same opportunity as other voters to participate in the political process and to elect representatives of their choice. And so you put these 3 cases together, what you see is that there is a deep skepticism among the conservatives on the court, and these were all cases where the conservatives and liberals split. There's deep skepticism among conservatives on the court about protecting voting rights, either the ability of Congress to protect voting rights or the ability of plaintiffs to come in where there are states that have passed restrictive voting laws and to challenge those in court. And so really the kinds of tools that we thought people had to protect voting rights are being whittled away by the Supreme Court. And so it becomes a struggle not only to get people to register and to vote, but to get them to register and vote under, in some places where there are new restrictive voting rules. So we cannot count on the federal courts to provide the kind of protection that we hoped we would have been able to in the past. Unfortunately, we cannot count on the federal courts to be the main protectors of voting rights, that they are the ones that are no longer going to be, as the court was in the 1960s and in part of the 1970s, no longer the main protectors of voting rights. And so that means that there's going to be struggles. Not only do we have to get people to register and to vote, but in many states, we have to get them to overcome restrictive voting rules that are being imposed on states, not because they're necessary to protect the integrity of elections, but instead because they are simply there to make it harder for some people to register and vote for partisan advantage.
Can you talk about Brnovich and whether the court, the majority, are really contemptuous of the actual text of Congress in the VRA and ever since the 1982 amendments? And has any other area seen the court really imposing their own text and agenda on Congress? And what does that mean for so-called originalism and textualism?
So in the Brnovich case that the Supreme Court decided this past July, the court was engaged in an act of statutory interpretation, not constitutional interpretation. So it was deciding what Section 2 of the Voting Rights Act means. And in 1982, Congress reenacted parts of the Voting Rights Act and revised Section 2 of the Voting Rights Act to make it easier for plaintiffs to bring suit, claiming that a voting law deprives minority voters of the same opportunity to participate in the political process and to elect representatives of their choice. One of the things that Congress pointed to in its very influential Senate report that accompanied the passage of the revisions of the Voting Rights Act in 1982 was this danger that states and localities could pass voting laws in the name of preventing fraud or promoting voter integrity, when in fact what they're trying to do is to suppress the votes of minority voters. And what Congress said was that courts need to be on guard against this kind of attempt to engage in this conduct. The name for this was tenuousness, that there was a tenuous connection between the stated goals that the state came up with for restricting voting laws and the evidence on the ground. And in the Brnovich case, 6-3 decision, all the conservatives on one side, all the liberals on the other side on the court. Justice Alito, who's among the most hostile to voting rights on the Supreme Court, Justice Alito turned the Voting Rights Act Section 2 on its head and essentially gave states a free pass. So if a state, for example, to make this very concrete, if a state says it needs to pass a restrictive new voting law because it is trying to prevent fraud, we should take that at face value. We should take that at face value because you shouldn't have to wait until there's lots of fraud before a state can take actions against that danger. This, in spite of the fact that the two Arizona laws at issue, there was no evidence that there was any fraud connected to elections in Arizona using these methods that were challenged. And so Justice Alito, in his opinion, really turned things on its head. If he were trying to be faithful either to the text, looking at what it means to deprive minority voters of the same opportunities as others to participate in the political process and to elect representatives of their choice, or he was trying to engage in looking at legislative intent by looking at the materials that accompanied the passage of the revisions of Section 2 in 1982, he would have concluded that Congress wanted to put a thumb on the scale to favor minority voters. And in fact, he did quite the opposite. He made it very easy for states to restrict voting rights. And in fact, the entire Brnovich opinion reads much more like a guide for states to defeat claims under the Voting Rights Act than it does an attempt to try to make things better for minority voters.
Let me throw out, thank you for that, maybe three more questions. Deal with them as you wish. In Alito's opinion, he has a rule that if a law or a procedure was good enough in 1982 when the VRA, the Voting Rights Act, was amended, then it's good enough today, even though the Voting Rights Act has been an arc of inclusion of more and more people and less discrimination in voting rights. Second thing I want to throw out is gerrymandering. Section 2 has been used in large part in Justice Department pre-clearance of redistricting and gerrymandering. And what does Brnovich do to that very, very powerful tool, which really was enacted in 1965 to prevent a state from simply enacting another law and dragging things out for 2 years of long and expensive litigation. Third and last, we have a new HR 4, the John Lewis Voting Rights Advancement Act, which the House just passed last week. and is now in the Senate. It's been said that gerrymandering alone could flip the House. HR 4 seems to be the most brilliant piece of the most brilliant bill I've ever seen in going case by case and almost sentence by sentence and test by test and Congress overruling, rejecting, and nullifying those, and telling the Supreme Court what it wants in terms of its decisions and jurisdictions. So there are few issues for you to chew on if you wish.
Sure. So let me start with gerrymandering. The Brnovich decision doesn't speak to how Section 2 applies in the context of redistricting. It speaks only in the context of vote denial cases. So if there's any bit of good news about Brnovich is that it didn't touch the protections for voting rights that are provided for in relation to the protection of districts where minority voters have the ability to elect representatives of their choice. But the news is not good when it comes to gerrymandering. We're entering into a new decade of redistricting following the release of census data a few weeks ago. And already the Supreme Court in other cases, cases we haven't talked about, including most recently the Abbott versus Perez case, the Supreme Court has shown itself shrinking the reach of Section 2 when it comes to redistricting. At least two justices on the court, Justices Thomas and Gorsuch, have indicated they don't even think Section 2 applies to redistricting. So I think as we get new challenges under Section 2 of the Voting Rights Act, we can expect the Supreme Court to be continuously hostile to Voting Rights Act claims and reading the act very narrowly. Again, I think not in line with either the text of Section 2 or the legislative history of Section 2. In terms of the John Lewis Voting Rights Advancement Act, there are provisions that would restore some of the interpretations of the Voting Rights Act in the redistricting context that would help plaintiffs. And in addition, as you mentioned, it would limit partisan gerrymandering to some extent. HR 1 really has the biggest ability to do that. Both of these laws are out of the House but stuck in the Senate, and I'm not at all optimistic that anything is going to pass. And so you couple the legislative failure to deal with gerrymandering with the Supreme Court's decision from about a year ago in a case called Rucho versus Common Cause out of North Carolina, which said that trying to challenge partisan gerrymandering under the Constitution it's a political question that federal courts can't get into. We're going to be entering into a redistricting season where there's no longer protection under Section 5 of the Voting Rights Act, that preclearance provision. Section 2 has been weakened. There is no direct policing against partisan gerrymandering. And so there are many fewer tools to go into federal court if you're a plaintiff to try and go after what we, as we saw in the last decade, egregious attempts to try to manipulate the political process through the drawing of district lines to protect one political party or protect a group of incumbents. So I think, going forward, the message on voting rights, and this ties together, I think, what I said earlier with what I'm saying now is those who look to federal courts as the great protectors of voting rights are going to be profoundly disappointed. This is a court that, if anything, is protecting states against claims of restrictive voting rights, that is protecting states' ability to draw districts to favor one side or another. And so I really think that it might be state courts, it could potentially be Congress if things change in the future, but the hope that federal courts are going to play the role that they played 50 years ago, 40 years ago during the Warren Court and the early Burger Court, I think that is misguided and not where we should be looking for our savior right now. What I can say more generally is that back in 2018, I made an argument that now has picked up a lot of steam, which is that if you're going to get rid of the filibuster for things like judicial nominations or executive nominations. You should get rid of the filibuster for laws that protect the right to vote. And I think politically, that's very difficult for Joe Manchin or Senator Sinema. But it's really the only way that we're going to get things done if is to pass it with 50 votes. If that can happen through reconciliation, that's great. If it can't, I think we need a more straightforward way of dealing with the fact that voting itself has become a polarizing issue. When the Voting Rights Act was amended in 2006, it passed the Senate by a vote of 98-0, passed by a very lopsided vote in the House as well. Now it's very hard to find any Republicans who are willing to co-sponsor voting rights legislation, not HR 1, not HR 4, not anything else. I don't know what it's going to take politically, but this is the moment where we desperately need Congress to pass voting rights and to pass strong voting rights that can sustain a challenge in the Supreme Court. I'm not optimistic that it's going to happen, but I think this is the moment we're sounding the alarm, and really no one should be surprised if things with voting get much worse in this country if Congress doesn't find a way to act.
Thank you so much. Let me just conclude with this yes or no question. Everything that you've talked about, do you think that our democracy itself is truly at risk and in danger, as President Biden said at Arlington on Memorial Day, and others have, and perhaps you have too in some articles? Is democracy itself at stake? Yeah,
democracy is at risk, not because of what we've been talking about, though, not because of the danger of voter suppression, as terrible as that is, but because of the danger of election subversion, the idea that those who count the votes and run elections might not do so fairly. That's a topic for a different day, but we're spending a lot of attention on this at the Fair Elections and Free Speech Center at UCI Law. And I invite all of your listeners and viewers to attend our virtual conference on election subversion and American democracy, which is going to take place on September 24th from 9 a.m. to noon. Virtual conference. First speaker is going to be Brad Raffensperger, the Secretary of State of Georgia, who stood up to Trump when Trump asked him to find 11,780 votes to try to flip the election to him. It's a different topic, but it's an urgent topic for American democracy.
And the three disinformation in American elections in October.
Those are October and November, right? Those are coming up. And on September 9th, we have Michelle Goodwin, who was just on with you, along with Jack Balkin of Yale and Michael Klarman of Harvard, talking about whether the U.S. Constitution is up to the task of preserving American democracy.
Thank you very much for being so generous and gracious with your time, and be safe.
You too.
And let's hope American democracy is safe.
Yes, I agree. Thank you.
So now we turn to Eddie Tabash. He's one of the most knowledgeable lawyers on religion cases, the U.S. Constitution's free exercise and establishment clauses. He's written and filed many briefs and cases in the U.S. and California Supreme Courts and federal and state courts of appeal. Eddie is chair of the board of directors of the Center for Inquiry and a member of the board of trustees of Americans United for Separation of Church and State. And he'll talk to us about the Supreme Court's religion cases. It's all yours, Eddie.
I want to thank Jonathan and Sue for having me to make this presentation. It's a very difficult time. The ominous takeover of the Supreme Court by a 2/3 religious right-wing majority places the separation of church and state in grave, grave jeopardy. One of the most important formulations of the concept of church-state separation was expressed by the court in the 2005 case of McCreary County versus ACLU, where the court said that no branch of government can favor religion over irreligion. With limited time today, I want to focus on one aspect of the threat to government neutrality between believers and non-believers. This is the special privileging of religion dressed up in the garb of the free exercise clause. The purpose of this clause is to make sure that no one, believer or non-believer, suffers any fewer rights than anyone else because of one's views on matters of religion, regardless of what those views are. This is being twisted by the 6-3 religious rights supermajority on the court to allow only religious objectors special exemptions from laws that are otherwise applicable to everybody else. If special legal rights are provided to only the religious to avoid compliance with laws of general applicability, then the free exercise clause is being used to nullify the establishment clause. The goal is for no one in the United States to have more or fewer legal rights than anyone else just because of their views on religion or on a deity. In 1990, in Employment Division versus Smith, the Supreme Court held that one's religious beliefs does not require government to grant that individual any special exemption from laws binding on everyone else. This was the correct interpretation of the religion clauses of the First Amendment. But in 1993, Congress passed the Religious Freedom Restoration Act, known as RFRA, in an effort to legislatively overturn the Smith decision by requiring all branches of government to demonstrate a compelling interest before refusing to grant exemptions from complying with otherwise generally applicable laws to only religious objectors. Government did not have to show a compelling interest when refusing such an exemption when the request was not based on religious opposition to complying with the law. It was disheartening to see many civil libertarians who should have known better support RFRA when it is a clearly unconstitutional grant of special rights to only religious claimants. Starting with the 2014 case of Burwell versus Hobby Lobby, we've seen the slide towards special exemptions from generally applicable laws for only the religious, when a court majority held that the Religious Freedom Restoration Act will allow for-profit companies to deny their employees health coverage for contraception, to which the employees would otherwise be entitled, and this is based only on the religious objections of the company's owner. In Little Sisters of the Poor versus Pennsylvania last term, the court decided that the Department of Health and Human Services had authority under the Affordable Care Act to promulgate rules exempting employers with religious or moral objections from providing contraceptive coverage to their employees. The gratuitous throwing in of a moral objective was a transparent attempt to show that the right to withhold contraceptive coverage from one's employees can have a moral foundation separate from religion, but this fools nobody. The court did not directly decide whether employees with religious objections to providing insurance compensation for contraception can also opt out of notifying the government or the insurance company. Now, some religious employers claim that even providing such notice puts the religious objector in the causal chain that results in the employees ultimately obtaining such coverage. In 2015, in Priests for Life versus United States, a Catholic organization of priests didn't want to even fill out a notice form to the government or the insurance company giving notice that they won't be providing coverage for contraception. They claimed that their giving notice triggers the process by which their employees will finally obtain such coverage. The case was heard by all 12 judges of the Federal Court of Appeals for the District of Columbia. The priests lost, but Kavanaugh, 3 years before Trump put him on the Supreme Court, was one of 3 dissenting judges who would have allowed the priests to avoid complying with this bare notice requirement only because they said that doing so offends their religious beliefs. Another example from last term is the court has always recognized a ministerial exception to nationwide employment discrimination laws. Now, this means that religious institutions can hire and fire for any reason anyone whose job description involves proselytizing, teaching, or preaching the religious doctrine in question, which means primarily clergy. However, last term, in the case of Our Lady of Guadalupe versus Morrissey Beru, the court extended the ministerial exception to non-clergy employees and allowed a Catholic school to fire employees for any reason without accountability to employment discrimination and disability laws. In this case, one of the terminated employees claimed she was fired because she came down with breast cancer, and the court wouldn't even let her bring such a case. Once again, the special privileging of religion. Only religious institutions are permitted to fire any employee for any reason and not have to answer to our country's employment discrimination and disability laws. In Masterpiece Cake Shop versus Colorado Civil Rights Commission, the court ruled in favor of a wedding cake baker who does business with the general public who refused to bake a wedding cake for a same-sex couple. The court didn't directly rule all such discrimination was permitted to a religious objector. And it kind of punted on the fact that members of the Colorado Commission expressed hostility toward the baker's religion. Still, this is an ominous gateway to allowing religious objectors to be the only ones permitted to avoid complying with otherwise generally applicable anti-discrimination laws. Only the religious have this special exemption. A few months ago, the Supreme Court decided Fulton versus City of Philadelphia. It was decided in June, and this was a horrendous loss for us. Here, Philadelphia found out that some of its foster care providers would not license same-sex couples to be foster parents. The city ceased referring children to these agencies, including Catholic Social Services. The Catholic group sued the city, arguing that it was a constitutional free exercise of religion right to refuse to allow same-sex couples to become foster parents because of the church's opposition to same-sex couples. The Catholic group got the court to agree that any religious organization has a special right to be exempt from any branch of government's otherwise universally applicable law prohibiting anyone from funding discriminatory foster care and adoption programs. This is a most egregious instance of demanding and actually obtaining an unconstitutional special privileging of religion. A government-funded program should not assist those organizations and individuals involved in placing children in foster care who would reject potential foster parents just because they are an LGBTQ couple. Taxpayer dollars should not be given to those who would use those dollars for the imposition of religious-based discrimination. On February 5th this year, the court decided the case of South Bay United Pentecostal Church versus Newsom. Here, the 6-3 religious right majority voted to strike down a number of restrictions that California had in place regarding indoor religious services due to the COVID virus. There are three sets of restrictions the court dealt with. One restriction prohibited all indoor religious services in Tier 1 areas, those parts of the state with the highest infection rates. Another restriction limited religious gatherings in other parts of the state to 25% of capacity. The third restriction prohibited chanting and singing in all indoor services. The result was that the 6-vote supermajority of the religious right allowed indoor religious services in all areas of the state, regardless of infection level, and at 25% capacity. The ban on chanting and singing was upheld because of the overwhelming evidence of how such conduct will spread the spores of the virus. The 6-vote majority invited houses of worship to submit evidence that they were being singled out for special deprivation of gathering rights, claiming that they were the only ones to suffer this discrimination. Now, among the 3 justices who dissented, Breyer, Kagan, and Sotomayor, Kagan wrote a powerful dissent. She pointed out that California did not single out religious gatherings for any fewer rights. The state grouped together political meetings, attendance at lectures, movies, plays, concerts, and the hospitality industry. There was no singling religious out for invidious discrimination here. Religious gatherings were grouped with other types of gatherings based on proximity and length of time and exposure, having nothing to do with whether the gathering was religious or secular. In its effort to provide preferential treatment for religious gatherings, the majority ignored science. California provided experts showing how shopping for groceries differed from worship services in the amount of droplets to which those engaging in either activity were exposed. And the court ignored this. On April 9th of this year, in Tandon versus Newsom, the court issued an injunction against a California law that will remain in place pending a full hearing. The injunction will for now continue to bar California from imposing the same restrictions on religious in-home gatherings as it does on secular ones. This is another example of a Supreme Court majority's favoring religion over non-belief. This was a 5-4 decision. We got Chief Justice Roberts to dissent along with Breyer, Kagan, and Sotomayor. However, because the religious right has a 6-vote, 2/3 majority on the court, they can prevail even on those rare occasions when Roberts defects to the church-state separation side. The goal, which the current Supreme Court is ignoring, the goal of the United States Constitution is for believers and non-believers to be equal before the law, and no one suffers any greater or lesser rights because of either accepting or rejecting any tenet of religious faith. And thank you for letting me make this presentation.
Well, thank you for laying out such a comprehensive background as well as a report on the court's current free exercise and an establishment religion cases. Excuse me. I have just one question, at least for now. When the court decides a case, it applies all kinds of doctrines, rules that most people are unaware of, such as the level of scrutiny. And in the case of the COVID and church cases, comparison of the activity, of the nature of the activity. Does it look to you like the judges first, at least the conservative justices who ruled against the ability of California to regulate, does it look to you like they first reached a decision and then figured out how to justify it by what they compared, what activity they compared to others?
Absolutely. What they did was they shot an arrow into a tree and then drew the bullseye around the arrow, not the other way around. Absolutely. If you look at Kavanaugh and you look at his firm belief that the religious have special rights to be exempt from all laws that displease the religious objector's religion, you see that he will do anything he can to fit the decision into allowing religious objectors to be the only ones that can escape abiding by laws that bind the rest of us. Absolutely. These are not principled decisions.
I haven't. One more question. Three of the justices, really the most conservative, Thomas Alito and Gorsuch, have rather overtly stated that they are ready to overrule the case that you mentioned, Employment Division versus Smith, the 1990 case that held that rules and laws and regulations of general applicability are presumed to apply to religious entities and religious affiliated ones. What do you foresee as the future of that precedent, which is now 31 years old, being overtly overruled?
I think that unfortunately it will be overruled. And I think that because these justices see the free exercise clause as a weapon to allow the religious to do whatever they want, as opposed to the rest of us, they will have to overturn Smith as being inconsistent with their interpretation of the free exercise clause. So I'm very afraid for Smith. I don't see it surviving. And even if it's a 5-4 decision, it still gets overruled. The most awesome tragedy was when Ginsburg died last year, and Trump was able to replace her on the court a week before he lost the election. We always feared a 5-4 religious right majority. We weren't ready for a 6-3.
Well, thank you very much. And thank you also to our other presenters, UCI Law School professors Michelle Bratcher Goodwin and Rick Hassan, for their segments. And thank you, viewers, for tuning in. And please be aware of the purpose of this series of Supreme Court term reviews, which is to indicate, among other things, how important it is who sits on the court, and therefore who appoints the justices who sit on the court, and how its decisions affect the lives of everyone. Thank you for tuning in to another program of Concerned Citizens Presents, airing every Wednesday at 1 o'clock on Village Television. Have a safe rest of the day and week, and we'll see you next week. Thank you.